Moving on to Article 19 of the Constitution of India, which talks about essentially freedoms that citizens have a right to. Uh, Article 19 of the Constitution says that protection of certain rights regarding freedom of speech, etc. 19.1 All citizens shall have a right to freedom of speech and expression, that is 19.1a. They shall have the freedom to assemble peacefully without arms. They shall have the freedom to form association or unions, to move freely across the territory of India, to reside and settle in any part of the territory of India, and finally to practice any profession or to carry on any occupation, trade, or business. These 19 Article 19 freedoms are essential freedoms because I think what they do is they protect the private rights of citizens. And there is always a legitimate expectation of citizens that the freedoms that exist are some of these rights are not alienable rights. That means they are supreme rights, they cannot be sacrificed or given away or even waived off. And I think when you create a state out of we the people, you expect the state to actually protect these rights in all possible circumstances. Of course, you will notice that the freedom of speech and expression is top among these because it is a matter of liberty of thought process and expression that is integral to anyone's personality, especially the personality of individual who reside in any democratic society or in any democratic process. Uh, Justice Krishna here had said something like this. He said this freedom is essential because the so-called power of the state to censor has to be regulated because if the government does not have a limitation on censorship, then it would go against the will of the people. It would go against democratic principles, and hence the freedom of speech and expression thereby is the core to how government is supposed to behave, and when can government intervene and when it cannot, especially on the speech and expression provisions. Uh, One should understand that freedoms are very, very important and a healthy process in any democratic institutions or legal systems. I think the protection of these freedoms is the test of the legal system, and the moral and intellectual life of an individual are only enhanced when these freedoms are actually protected, nurtured, and valued in any legal system. Now, if you look at the freedom of speech and expression, friends, it is important that you exercise some of these freedoms to find out or discover truth, because truth is the biggest trust deficit, which can actually bridge the trust deficit that exists between the government and its citizens. It ensures pluralism, it ensures democratic value, and it has a sense of self fulfillment among citizens whenever they exercise their freedom of speech and expression, either through their own self or through other means of print or social media, as the case may be. India has always nurtured democratic values, and it has been a sovereign that has protected the republic's democratic structure. And I think the freedom of speech and expression is the foremost of human rights, and it is something that must look at public administration processes about when and how the freedom of speech and expression gets infringed, and when the courts will have to come into the picture. For example, in Bennett Coleman Company versus Union of India, the Supreme Court has held that newspapers are an integral part of the process of freedom of speech and expression under Article 19. They exercise what we call as the freedom of the press. Now, the press must have speech, must have expression. The press is the one who reaches people with information about the various aspects of happening both regionally, nationally, and internationally. And hence, if there are any kind of restrictions on the freedom of the press, it does violate someone's or citizens' freedom of speech and expression. So what had happened in Bennett Coleman and Company versus Union of India is that there was a constitutional challenge to the validity of an order passed by the government called the Newspaper Price and Page Act of 1956, which empowered the government to regulate the allocation of space for advertisement, because advertisements were consuming a huge part of the newspaper publication. So they sought to control, they means the government sought to control the space for advertisement, in a sense that this would amount to curtailing advertisements in newspapers, so that there is scope for other kinds of news. So the government justified it. However, newspapers, actually, they sell newspaper at a very subsidized cost, and through the revenue of advertisement, they actually cover the cost of publication of the newspaper. So I think what the court said was it would directly impact circulation, because newspapers then will be expensive, and this in turn would affect the freedom of speech and expression of individuals who would like to get information from these newspapers. And the press had an important role to protect and promote the freedom of speech and expression. The other case that you see on the slide is the Indian News Paper versus Union of India case, the Indian Express case of 1985. This also looked at the newsprint control order, which regulated the supply and distribution of newsprint in the country. Again, something that was indirectly attempted to control the press by an order that was passed by the government. And the constitutionality of such a newsprint control order was again challenged. Was it necessary? Was it reasonable? Was it in public interest, or did it attempt to somehow, kind of curtail the freedom of the press? So, what the court said is that the directive principles of state policy uh, under Article 39B and C requires the state to ensure that the ownership and control of material resources, which includes newsprint as well, are subservient to the common good, and it is best served to the common good, being reasonable in its restraint. Um, so I think sometimes the government is able to justify the interference in newspaper, but please note, interference vis-a-vis the content and circulation of newspaper would violate Article 19(1)(a). So the courts are very clear in not permitting governmental interference in such matters. In another case called the Secretary, Ministry of Information and Broadcasting versus the Cricket Association of Bengal, the Supreme Court held that broadcasting is a means of communication and a medium of speech and expression within the meaning of Article 19(1)(a). This case involved the right of Cricket Association, that is the BCCI, to grant telecast rights to an agency of its own choice. It was held that the right to entertainment and to be entertained, uh, in this case, through broadcasting media, and an integral part of Article 19(1)(a), and if it is exclusively granted to only one agency, but thereby excluding the right of Indian citizens to watch it, would affect the freedom of speech and expression. Uh, so Article 19 thereby, friends, becomes a very critical aspect apart from the speech and expression. If you move on to the right of freedom to assemble peacefully and without arms, I think this is also very, very critical, right? And you will notice that the freedom to assemble is a part of the social structure and fabric that a citizen has. And you can definitely have this right to assemble very peacefully but without arms. This is a condition, and you will notice that time and again the police may call such an assembly as an unlawful assembly under section 144 of the CRPC. The police does have the right to intervene in certain matters, but taking away the colonial mindset that you need permission every time to assemble, I think there is an essential freedom of assembly that exists among the citizens as well. Um, so I think to a larger extent, you will notice that the police can intervene into an unlawful assembly. There is absolutely no doubt about it. But to the extent that it can do so, is very minimal because this is a constitutionally protected freedom, and you have the right to assemble, you have the right to form association after assembly, or also to form union. Also, the freedom to move freely across the territory of India. I think that is a very essential freedom that does exist, and any kind of restrictions on assembly, association, and movement are to be evaluated under the constitution provisions as well. For example, a person suffering from AIDS can be restricted of his movements. Now, these are what we call as the reasonable restrictions that can be imposed on your freedom. So, none of these freedoms are going to be absolute. So, an AIDS patient has this risk and vulnerability of spreading the disease of AIDS, and hence, can his restrictions can be imposed on his movement? The answer is an absolute yes. And you will notice that Lucy R.D. D'Souza versus the state of Goa. This is a case decided by the Bombay High Court in the year 1990. The court did say that this is a potential risk. The movement is a potential risk for the public community, and in public interest, such kind of movement can definitely be regulated. Now, any policy that is laid down that takes away any of these freedoms, you will notice, ought to be very, very reasonable and cannot be arbitrary. Uh, so, among all of these freedoms, please note, can the political parties call a ban as a part of their freedom of speech and expression, as a part of assembly, peacefully, association, union, or even movement freely across the territory of India? Now, bunds and industrial strike are entirely two different concepts. Industrial strike is a labor kind of a collective bargaining process. After giving due notice, an industrial strike can be a legal strike. You are permitted to do the same. However, a band is usually political in character and nature, and a band usually tends to shut the public spaces. It tends to shut down essential services sometimes. There is a general lockdown of the city or the village or the kind of municipal area. So it has a larger impact, and one would assume that calling of these political so-called ban becomes a very frequent practice for the political parties to show their protest. Now, whether the freedom of speech and expression has the element of right to protest, the answer will be in positive, it will be in affirmative. Yes, you have the freedom of protest, but again, the protest has to be peaceful, the protest has to be without arms. However, a band, if it has an element where the legislature would like to regulate band, the police would like to regulate band, a band prevents someone from getting gainful employment or gainful work. If a band actually affects the right to study of students, then in that interest, the band can actually be held to be illegal as well. So I think those are aspects of band wherein the public interest of other citizens to say peacefully staying in a society over the political party's right to call a band will always be regulated. Okay, so you know, of course, one would notice that none of your freedoms can violate things like, say, the guidelines that are issued from time to time on contempt of court. So you will notice that contempt of court means causing disrepute to the majesty of the court or majesty of justice or the institutions of justice. And in case you do exercise any of your freedoms unreasonably and arbitrarily so as to cause contempt of court, then you could probably be punished for the same. So I think this is something that people will have to, understand that look, uh, while you have the freedom of speech and expression, you do have the right to criticize. A fair comment or a fair criticism is permitted under the Constitution. However, if the criticism is of the judge and not the judgment, and if the criticism lowers the dignity of the institution or causes or instigates people from having faith in the institution of the judiciary, then such kind of matters can be held to be contempt of court. One must understand that while the judges are not very hypersensitive, they are amenable to public opinion, and any kind of overstep on the aspects of criticizing the institution of the judiciary may amount to contempt of court. So, this is one of the reasonable restrictions that is there in Article 19.2, that you are not supposed to exercise any of your freedom so as to cause contempt of court. So, uh, there is a very important provision which says that in case you are going to exercise your freedoms, that results in or prevents in the administration of justice or amounts to obstruction of public justice, such kinds of confusion, words, reporting should be avoided, and your personal freedoms cannot be used to defend any kind of obstruction of public justice. So you ought to know your reasonable limits in exercising of some of these freedoms, and only then the Constitution is in your favor to protect some of these rights. One of the questions that has often been asked in Article 19 is about convicts or accused or under trials, and whether accused and under trials have also some of these freedom of speech and expression, assembly, association, dissident, movement, profession. The answer is yes, convicts are not excluded. However, you will notice that they have certain kinds of restrictions or guidelines within which the convicts or the under trial or those who are in jail will be forced to exercise. For example, in a case whether a convict can write a book within a jail as a matter of freedom of speech and expression, I think the courts did hold that yes, this is definitely possible. This case is popularly called as the Otto Shankar case, where Otto Shankar was he was a criminal, a convict on death row, and he wanted to write a book. Whether he has the right to do the same, the court said yes, he does have the right to do the same, and that is something that need not be restricted by any actions of the state. Uh, Now, under Article 19, while we say that citizens have the right, now does the word citizen also include a corporate citizen? Now, we should understand that corporate citizens are also important and integral part of the Constitution of India. And if you do a literal construction of the word citizen, it may not include corporations. However, you will notice that corporations, through their shareholders, can definitely exercise Article 19, and the shareholders of a corporation can go to the court on the grounds of violation of their fundamental rights, and they may actually attach the company along with them as well. So, though a company is not a citizen per se, I think through the elements of the shareholders, the companies can be brought about within the structure of Article 19. Now, the freedom of movement, you will notice, is also critical and important because you are talking of movement across the territory of India. However, you will notice that certain kinds of restrictions are there in places like the Sentinel tribal islands in the Andamans. There could be some restrictions in places like the Northeast, which has a tribal region and a tribal belt. So it's not an absolute kind of a freedom to go and disturb people and community. You cannot infringe someone's personal liberty while you are exercising the freedom of movement. Nevertheless, for a legitimate purpose, you can always exercise this right. So the judiciary does not impose any restrictions on the physical or tangible aspects of your freedom of movement. However, the executive may have certain justifications to impose those kinds of restrictions at some point of time, especially to protect scheduled areas or scheduled tribe areas, or areas that are probably occupied by the army. They are sensitive areas in terms of scientific and technological explorations. So you will notice that under the Official Secrets Act of 1923, sometimes some of these areas are declared as restricted and prohibited areas, and people are not required to go to these places as a matter of their right. Of course, the freedom of the profession, or the freedom to practice any profession or carry on any trade or business. Now, this right under Article 19(1)(g) is also very, very important and a fundamental right, especially in terms of the business houses. Now, do citizens have the right to carry on business, earn their income, earn their livelihood, flourish their business in this country? Of course, they have, and hence this is part or integral part of the constitutional process. Yes, there could be a process of licensing certain kinds of trade or profession. The state may require you to take a trade license. There could be some registration processes. The state obviously cannot prevent you from carrying on any business, but can the state impose reasonable restrictions on the ground of general public interest? Of course, I think businesses that are generally dangerous, immoral, or inherently hazardous will not be permitted by the state. For example, very recently you had Karnataka banning the business of lotteries. So they may think that this is not in public morality. Lotteries may have a tendency of promoting gambling or spending your saving, and those are the reasons why the business of lottery seems to be a regulated, prohibited kind of an activity currently in Karnataka, though it was permitted at some point of time in certain kinds of states. So, the right to business is not at all places and at all times, and hence, place and time restriction also can be imposed by the state. And a citizen may be compelled to do business within those times prescribed by the state so as to protect public order. Uh, in a very famous case called the Ivory Association of India versus Union of India, the courts did intervene on this matter. They said that these ivory traders did not have a fundamental right to trade in ivory. Ivory is a protected kind of commodity and a product. You had to stop poaching of elephants or tuskers. Otherwise, the ivory trade was a flourishing trade, and these association members went and said, because there is a ban on killing tuskers or poaching these tuskers, our business is going to be affected adversely, and our right under 19(1)(g) is adversely affected. The court did not listen to the Ivory Traders Association, and they said that you have to sacrifice, you have to close down, you have to probably shift to some other trade, but ivory trade cannot be allowed as a matter of your freedom. So, restrictions on these kinds of trades that are dangerous, immoral, against public interest are something that the government can impose from time to time, and that is something that the courts may be permitted to upheld as constitutionally valid as well. Of course, one should understand that Article 19 is an all encompassing freedom, and any kind of restriction on the freedom should be through the process of a law, and not just merely by an executive fiat. So, I think the courts have said that it is the legislature in its wisdom that can impose reasonable restrictions, but it should not be done in a routine manner. So this the process of lawmaking can be the process of imposing reasonable restriction, as the case may be. One such case of a law that trying to restrict your freedom under Article 19 was something that came by the Information Technology Act of 2000. Now, friends, what happened in a case called Shreya Singhal versus Union of India is that two judge bench of the Supreme Court in 2005 looked at the regulation imposed by the IT Act on your online speech and on intermediary liability. Now, see, offline speech and online speech are two different, connotations. Online speech has a larger basis of reaching, and you have your constitutionally protected right. Now, interestingly, Section 66A of the Information Technology Act of 2000 set to impose some kind of a restriction on these kinds of online content or online speech. Now, what it said is that under 66A, it would be a punishable offense if a person sends grossly offensive information through a computer resource, which means, if suppose someone sends information which he knows is false, which he knows will annoy or cause inconvenience or danger, insult, injury, or criminal intimidation. It may arouse enmity, hatred, or ill will towards any kind of community. Then Section 66A said that such kind of electronic mail messengers, which are carried on for this kind of purpose to mislead, deceive, cause vagueness and arbitrary kind of messages, which are sent usually by people both out of personal vengeance or political vendetta. Then in those circumstances, that online speech can be a punishable offense under Section 66A of the Information Technology Act. Now, Shreya Singhal actually challenged this, and the Supreme Court struck down Section 66A, and they said that look, and this was a judgment delivered with Justice Nariman. He said that if you have to impose any kind of standards on the freedom of speech and expression, then those standards can only be as per Article 19(2) of the Constitution, and no new reasonable restriction standards can be imposed by a new law. That new law has to be in consonance with the constitutional principle and cannot be against the same. So I think online and offline speech have the right of equal protection under Article 14. So online speeches cannot be treated differently, and online speech cannot be an offense, whereas an offline speech on the same matter is something that is not taken cognizance of. So I think that kind of a distinction cannot be made, is what Justice Nariman said while he read down Section 66A. While one says that this is a very, very significant judgment under the Shreya Singhal's case, you will notice that the content of fake news, fake message, or trying to instigate a community through online is becoming a major problem in today's times, and the courts are dealing with this issue in a slightly different manner. So the Shreya Singhal case only was on the point that offline and online speeches cannot have two different standards of restrictions. They have to be same and similar, and only then there can be intervention regarding your freedom of speech and expression. So, ID Act is a law. There is absolutely no doubt about it. But Section 66A that tends to impose any kind of restriction on your freedom of speech and expression was held to be not valid per se to that extent, because it was not equal in terms of offline and online speeches. So that is also a very important intervention that the Supreme Court said, and the constitutionality of 66A was tested, and it was set aside. Now, one of those important aspects, friends, is that trial by media. I think trial by media today is a very common process of the freedom of the press. To some extent, you will notice that this has been misused and abused by the media. They are actually deciding the guilt of an accused before even a court of law can actually do the same. We are in 24 into 7 news in the audiovisual content space. There is a lot of appetite to online content, online media, and the media has a tendency to actually sensationalize criminal cases, and there is a lot of public curiosity, and I think there is only an upsurge of that curiosity, and people would want to predict the outcome of a case even before the courts can reach that kind of a place, and the journalists are actually harping on to such kinds of news and making their conclusions and making their final prediction of their outcome. This thirst of sensationalization of news is a major problem right now, though sometimes sensationalization is a normal human nature and a character or a human desire, as the case may be. And sometimes such kind of media trials are justified under the name of investigative journalism. But does these kind of media trial have the potential risk of damaging the following? First, a media trial has a huge element that can actually damage the reputation of an individual who is an accused who is considered to be innocent till proved guilty otherwise. Of course, media trial definitely infringes the privacy of an individual. And finally, don't forget that it can amount to contempt of court because it has an element of influencing the judge and the outcome of the case simply by what is being reflected in the media. And because everyone is in tune with the media, everyone is open to media scrutiny and media trial. So I think currently, as we speak, the Press Council of India has come up with certain guidelines so that the trial by media does not affect the reputation, privacy, and amount to contempt of court. Now, all of these are the guidelines that are issued to the press so that while they exercise their freedom, they do not actually violate the rights of others. It is very, very important that the media acts with responsibility, the media acts with a sense of duty and purpose towards the constitution, legal system, and towards the rights of other individuals as well. So the media, for example, has been prohibited from naming the victim of sexual assault. The media has to have sensitivity in calling for opinion of individuals and people. And I think if any of the media persons attempt to influence administration of justice, they could be held liable for contempt of court as well. So that I think has been a very recent outcome of the misuse and abuse of Article 19 as well. Um, Finally, if one looks at the aspects of reasonability, one would notice that all freedoms have to be exercised in a very, very reasonable manner. And the term reasonableness is used on several occasions by the court of law, wherein tests and guidelines have been said by the Supreme Court from time to time in saying what should be the state policy in terms of protecting these freedoms and what should be the state policy in imposing restrictions on the freedom. One should notice that your freedom of speech and expression will stop as soon as someone's right to reputation begins. Your freedom of assembly will stop as soon as it turns violent. Your freedom to form association or union is okay until that kind of an association becomes unlawful. You can reside and settle in anywhere in India unless you are infringing the sensitive cultural, heritage of certain tribes in the country or certain state communities in the country. Your practice to any profession or trade or occupation is existing so far it does not affect public order, public interest, and the prevailing conditions for regulating those kinds of trade. So I think the evil of misuse or abuse of your freedom ought to be checked from time to time. There ought to be some kind of restriction from time to time. And I think the state has a right to intervene in both regulating your substantive freedom and regulating the procedural aspects to exercising these kinds of freedom as well. That is something that is the cornerstone of Article 19 of the Constitution of India.